Morning, Judge.
Morning. Morning, if you can all unmute and make sure that we can hear each other. Mr. Sanchez, if you can unmute, please.
Morning, Judge.
Morning. Uh-oh, I have an echo. All unmute. Hold on. And make sure that we can hear each other. Okay. Okay, can everybody hear me?
Yes.
Yes, I can hear you, Judge.
Okay. If everybody, or any witnesses, if you please raise your right hand. You swear the testimony about to give shall be the truth, whole truth, and nothing but the truth, so help you God.
Yes, I swear.
Yes, I swear.
Okay. So let me just get this arranged on my screen. 1 second. I don't know why it's not going down. There we go. Okay. Okay, so I think we were continuing with the CDC declaration contest. Who was questioning who and who Mr. Zimprich?
Yes, Judge, the only thing that was remaining on that was we had requested the September bank statements from his car washing business. I don't know if you've got a copy of that in the file. We sent that to the court yesterday.
Yes, once. Let me just get this screen arranged. 1 second. I apologize, but I don't get it the right way. I can't see everything at one time. Okay, let's see. Yes, I received it. Yes, the September statement.
Yes.
Okay.
So and we did send a proposed order. Our basis, you know, if we're in final comments, I don't think we have to question any further. If the court just takes the bank statement into consideration. Mr. Sanchez testified that he had the ability at all times to make at least a $200-300 payment. He didn't make so. The CDC order requires that the tenant make payments as close to their rent due as possible. Further, Mr. Sanchez submitted interrogatories under oath that he's making $500 a month, and he presents a bank statement with gross deposits of $2,800. Further, he has advised us that there were no cash deposits into that bank account. So all of the cash income that he received is not even showing in that. So it's our position he makes well over $3,000 per month. He uses that company bank account for multiple personal expenses. There's some meals on here in excess of $60. There's personal transfers to himself over $1,000, but you know, there's Starbucks for $20. You know, so it's obvious that Mr. Sanchez, you know, we have two positions, like I said, as to why the CDC declaration should be invalidated. Number one, he did not pay anything towards the rent, and number two, he can afford his rent and is just choosing not to pay his rent. If he's vacated, he's not going to be homeless. He's making $3,000 a month. He can obviously find other accommodations, and we're asking that the court allow this proceeding to continue.
Mr. Hernandez?
Yes, Judge, I did want to, because of the, I guess the elements of the CDC order, I did want to question Mr. Sanchez about a couple issues before the court rules.
Okay.
Okay. Now, Mr. Sanchez, when was the LLC started?
Started on August 20. I'm sorry.
Okay,
Started
and
on August 20.
you've heard the attorney say that there was some meal expenses that are in your statement. Can you explain that?
Well, the the meal expenses were pretty much due to the business. He's saying that I make like more than 3,000, which is that false. We did not receive any cash. We just received our checks, and all of them were deposited. Uh, Now, besides, that's not profit. I have my expenses. I need to buy new machines, chemicals, things like the business needs.
So what have you been paying yourself? Like for example, in September, what did you pay yourself from those deposits?
Pretty much, I pay myself around $500.
Okay. And now, have you had the opportunity to approach the management at the retreat to discuss the possibility of paying anything less than what they're asking for?
Yes, sir. We did. I tried to talk to Mrs. Erin, and since the beginning, we tried to make some arrangements, but Mrs. Larissa denied that, and they say that they want the rent to be paid in full, which I cannot pay it.
Okay, now let me ask you this. You received a notice to vacate on August the 4th of 2020, correct?
Yes, sir.
And Judge, I did introduce that document, and Ms. Molina told me she had attached it. You should have it.
Okay.
It's called a revised notice to vacate. It's actually in the handwritten by Miss. I think it's Erin Mansfield that handwrote it. Do you have that, sir?
I'm looking right now. I'm looking at, do you know, there's 4 exhibits. You don't know which one it is, do you?
Right. One is the one exhibit that
Notice,
I have.
notice to vacate, and there's the top of it is typewritten, and the bottom is, here, well, let me just share it. One second. Is that it?
No, that's the original notice to vacate. There's another one that's called the revised notice to vacate. That would be it, Judge. Now, can you scroll it down to the bottom of the? All right, Mr. Sanchez, do you see that total amount that they're asking for in the notice to vacate?
Yes, I do.
And that's $8,994, correct?
Yes, sir.
And that's the amount that they want you to pay, correct?
Yes, sir.
And do you have that amount?
I don't have it, sir.
Now, the reason, so the reason you haven't paid less is because they don't want less, right?
That's correct, sir.
Now, have you requested any type of rental assistance from any agency, government agency, nonprofit corporation, or anything like that?
Yes, sir. I try to call. I called Project Bravo and City General Assistance like 2 months ago to see if they can help me out, but they were just assisting people outside the city limits of El Paso, and they were pretty busy because there are other people that are also being asking for help as well. So they told me that they couldn't help me.
All right, then that's all I have from Mr. Sanchez, Judge.
Mr. Zimprich, do you have any questions for Mr.?
Yes, Your Honor, if I could do a screen share.
Yes. Oh, I'm sorry, one second. I think you can now.
Mr. Sanchez, do you see the credit card statement in front of you?
It's really little. Can you expand it, please?
Is that better?
Yes, sir.
Okay, so you have a charge to the Plaza Hotel for $334, correct?
Yes, sir.
Was that for a room at the hotel?
No, it was a dinner.
Okay, so you spent $334 on dinner. You have Pecking Garden for $43, correct?
Yes, sir.
You ate at Boss Chicken a couple times.
Mhm.
This is your gas that you're charging to the company, is that correct?
Yes.
Your meals at El Taco Tote, $32, $13. The $32, is that just for you, or does that include somebody else?
No, it's somebody else that I'm training to get into the company, and I invite him for a meal.
Okay, and you went to the brew house and spent $63, is that correct?
Yes.
What about Target? Is that for personal expenses?
That's related to the business and personal.
Okay. Did you ever send any checks or send any money to the office of the retreat?
No.
Okay.
Well,
But you-
in February, before February 2020 of this year, I'm sorry, I did pay everything on time, no
Right.
fees, anything like that. Everything was paid on time, and I
This
paid my
lawsuit
rent in February.
was filed for March, correct? So from March forward, you never sent any checks to the office to try to pay your rent.
No, sir.
That's
We
all.
tried to arrange, but they didn't want it to. So,
But
I
you
did.
never dropped off a check, mailed a check
No, sir.
for any money.
No, sir.
That's all we have, Judge.
Okay, Mr. Hernandez, you have another witness?
Yes, Judge, but I just want a real brief question of Mr. Sanchez regarding his employment.
Okay.
Mr. Sanchez, prior to starting the LLC, were you employed with the retreat?
No, since February when I stopped working with them. I wasn't employed till August that I started my own business.
Okay, that's all I have, Judge.
Okay. Any other questions or witnesses?
Yes, Judge, I would like to call, I issued a subpoena for Ms. Fragoso. I would like to call her.
Ms. Fergosa, you were sworn in.
Thank you, Judge. Good morning, Ms. Fragoso.
Good morning.
I'm going to be asking you a few questions. I just ask you that if you don't understand it or you need me to repeat myself, just let me know and I'll do so. Do you understand that you've taken an oath to tell the truth, correct?
Correct.
Okay, please state your full legal name.
Kitsia Larissa Fragoso.
Can you repeat that?
Kitsia Larissa Fragoso.
Oh, so Kitsa is your first name? Oh, okay. How long have you been working at the retreat?
5 years.
5 years?
Mhm.
And what's your position there?
Property manager.
And how long have you known Mr. Sanchez?
2018, 3 years.
About 3 years?
Mhm.
So how long have you been a property manager?
Going on 2 years.
Going on 2 years? Did you actually sign the lease that was executed by Mr. Sanchez and the retreat or the landlord in 2017?
No, when he actually leased, I was assistant. So the property manager, Daisy Duran, was the one that signed the lease with Mr. Sanchez.
Okay. Judge, can you share the lease on the screen, please?
Myself, me?
Yes, because I submitted
Okay.
it.
Okay.
attached.
It's one of your exhibits here?
Yes, Judge.
Can you see it?
Yes. Can you scroll to the bottom, Judge?
Last page?
No, just at the very bottom, there's the signature right there. There. Ms. Fragoso, do you see your name on that signature?
Mm-hmm.
So did you or did you not sign the lease?
I don't. My manager at that time and myself have the same approval codes, so she might have used mine.
Judge, I'm going to object to the line of questioning as how this is relevant to Mr. Sanchez's ability to pay at a CDC declaration.
How is this relative to the CDC?
I just want to establish what the rental amount is, but it was kind of interesting they're saying that she didn't sign the lease when obviously it was on there. But okay, I'll move on. So under the lease, Ms. Fragoso, what is the rental, the monthly rental amount?
It doesn't show. If you want to scroll up so I can see the rent.
Would be this page?
Yeah, go down a little bit more. All the way down. Tells you right there, $13.65.
Okay, thank you. Then you saw the notice, I guess it's written revised notice to vacate that was asking Mr. Sanchez for $8,994. You saw that earlier, correct?
Yes, sir.
Now, what amount I mean, you heard Mr. Sanchez testify that you would not accept anything less than the full amount. Is that correct?
He's actually never given me anything in writing. Never came into the office to see if we can help him whatsoever. So if you have any proof of that, I would appreciate you taking it to the judge because he's never asked us to help him with anything.
Okay, but you heard him testify that he spoke to Aaron and that
Aaron's
Aaron,
not here, and anything that goes through Aaron, it goes through me, and we ask for everything in writing for assistance. If he would have asked for assistance, we do payment agreements, and that's all through writing.
Okay, so now, all right. Now let me ask you, what was the amount that Mr. Sanchez was paying in rent prior to him being fired?
He was paying $200 plus his utilities while he was employed.
Okay. And is that an amount that you would be willing to accept?
No, because he's no longer employed with JRK.
Okay, so what amount of the 8,900 would you be willing to accept?
I'm going to again object, as this is not relevant to his ability to pay the monthly rent. I mean, basically at this point, the amount of rent is established and what he was required to pay is established. He's never tendered anything. So what they're willing to do in the future is irrelevant to what's happened in the past. The CDC ruling says that the tenant has to tender on a monthly basis, and he has not tendered anything since February.
Mr. Hernandez, I'm going to sustain the objection. I further think, I mean, now it's like, now you're trying to work out an agreement.
No, well, I'm not trying to work out an agreement, Judge. What I'm trying to determine is the witness's state of mind with regards to because you heard Mr. Sanchez testify that he spoke to Aaron and that Ms. Fragoso said they wouldn't accept anything less than the full amount. So I think it's relevant to broach that area. That's it.
Well, if you give her a specific instance that on such date, you know, you can question on those lines, but.
Okay, I'll ask her that. Ms. Fragoso, so basically you're disputing that Mr. Sanchez spoke to Aaron about making partial payments, correct?
Again, I can't testify her because she's not here. She's out sick. She's not on property. But like I mentioned, any payment agreement has to be written. So if Aaron did make anything, you would have something in writing saying that there was payment agreement. We don't do anything verbal.
No, but I'm saying you're disputing that
Yes.
Mr. Sanchez approached Aaron?
Yes.
But you don't know for a fact though, right?
Again, we do everything in writing. I'm more than sure, but I don't want to again. I'm not Aaron, but if you have a date and a time when it happened, I would be more than happy to ask her.
And you haven't asked her that?
that communication was not with me, and this is the first time you bring it up, so she's not here, so I can't ask her.
Okay, that's fair. That's fair. I don't want to ask you about anything that you don't know about. So you have no knowledge of that, basically.
Yeah.
All right then, Judge. That's all I have.
Okay, I'm going to stop sharing. Anything further, Mr. Zembrich?
No, Judge.
Okay, I'm going to rule that the CDC declaration is not valid, and I will, let me get the order. I printed the order, 1 second. I do find that Mr. had means to make a partial payment since we've never tendered. I also find that this will not leave us homeless. I'm going to sign the order, and we can proceed with the motion for summary judgment. I will get a copy of this to both of you.
Thank you, Judge.
Okay, Mr. Zembrich, you want to argue your motion for summary judgment?
Yes, Judge. As you know, we previously had filed an eviction case. That case was non-suited because there could have been some discrepancy about the rent as far as February was concerned. Therefore, since Mr. Sanchez had not made any payments, he's testified. We submitted an affidavit from Ms. Caleb Foraker. He's the Caleb, a gentleman. Miss Fregosa?
Caleb Foraker?
Yes.
Yes.
Okay. He's the analyst for the apartment complex and has the documentation on payments. He's testified that Mr. Sanchez has not made any payments for March through September. Mr. Sanchez has also testified in the previous hearings that he hasn't made any payments for October as well. Essentially, the rent for the 8 months at 1,300.
I'm sorry, Mr. Zembrich, the affidavit is it submitted, or do you have that?
It's attached to the motion for summary judgment. If you'd like, I can put it on the screen. It's a verification of the facts stated in the motion for summary judgment.
Okay, can you go ahead and share it on the screen?
So the facts stated within the motion for summary judgment were that the monthly rent was $1,365. Your Honor also has a copy of that lease. We've tried to keep it as simple as possible. We're not asking for the reimbursement of utilities. We're not asking for late fees, any of those amount. So $1,365 from March through October, which is 8 months, comes to $10,920. 5 days for November comes to $227.50, which would leave a total just for rent based on the lease of $11,147.50. The defendant has brought 3 arguments as to why the summary judgment should not be granted. One of those arguments is that the summary judgment provision of the Texas Rules of Civil Procedure does not apply to evictions. Texas Rule of Civil Procedure 500.3D, as stated in our brief to the court, states that evictions are governed by rules 500 to 507. So that provision of 503.2, which allows summary disposition of justice court rulings, is within that purview of 500 to 507. Now, the defendant argues that there is a conflict between 510 And I can bring up his motion or his response so Your Honor can see that. Basically, the defendant is arguing that to the extent of any conflict between Rule 510 and the rest of Part 5, which is Part 5 is the Justice Court rules, Rule 510 applies. And he is arguing that Rule 510 states that you can have an eviction by a judge or jury. Well, this does not create a direct conflict because it does not say you can only have a disposition of an eviction by judge or jury. It just says that a judge or jury can hear the case. So his argument that there's a conflict doesn't stand because those provisions are also in other debt cases and other provisions. So that would basically make the summary disposition rule not apply to any justice court case. So our position on that is that that does not create a direct conflict because it doesn't say only that an eviction case can only be by judge or jury, and it specifically includes summary disposition in eviction cases. The second argument is the eviction should be dismissed under the CDC ruling. That is now moot because we've already determined that. The third argument is that the eviction was done in retaliation. Now, section 92.332B1 states that an eviction or lease termination based on the following circumstances, which are valid grounds for eviction or lease termination in any event, does not constitute retaliation. Number one, the tenant is delinquent in rent when the landlord gives notice to vacate or files the eviction action. So in August, when we gave the notice to vacate and when the eviction proceeding was filed, the tenant was delinquent in rent, and that automatically negates any retaliation argument. The bottom line on our motion for summary judgment is that Mr. Sanchez has not paid rent for March through October, nor any rent in November for the first 5 days. We're asking for a judgment for possession as well as a judgment for the total of $11,147.50. I've created a proposed judgment based on the forms, standard forms of the Justice Court, which allows for appeal or rent during the pendency of any appeal, which is allowed under the Texas Property Code 24.0053. And we're also requesting attorney's fees. The notice to vacate did actually give the defendant 30 days to vacate. The amount for attorney's fees, which I've submitted a statement with the actual work entries. I have actually excluded all of the attorney's fees that were related to the prior case. You will notice that the entries begin August 4th. There's a total of 12.86 hours at $250 per hour, which is $3,215. Paralegals at $65 an hour. There's only 1.8 hours for paralegals. I've allotted 2 hours for preparation and attendance of this hearing, which gives us a total attorney's fees request of $3,833.30. In addition, we're asking for court costs of $146. And that would be the provisions of the proposed judgment that was submitted.
Mr. Zimprich, when you first started, you mentioned a name you couldn't pronounce, an affidavit of a name you couldn't pronounce. Where is that affidavit attached to your motion for summary judgment?
Yes, Your Honor.
Can you bring it up? I didn't.
It's a verified motion for summary judgment. I believe the provision says a verified motion is what needs to be submitted.
And it's the Ellen Mansfield. Is that the one you're talking about?
No, I believe that was our first motion for summary judgment.
Okay.
This is the motion for summary judgment. It was submitted to the court in this case. and it was submitted on September 16th.
Oh, okay, September 16th, okay.
Essentially, we had the prior case and we had the prior motion for summary judgment. We thought we might have a fact dispute about whether February rent was paid or not. And that's why we non-suited that case to remove February and remove any factual dispute as to whether rent for February was due or not due, because Mr. Sanchez did tender his portion of the rent for February. So this lawsuit has no evidence presented as to whether February was paid or not. We're not asking for anything for February. We're saying that March through October and actually November was not paid. And it's undisputed that that was not paid. Mr. Sanchez testified that that was not paid.
Can you bring your motion for summary judgment up on the screen and enlarge it, please?
About bigger than that?
Let's see. Okay. And can you go to the first page? And then go to the signature page. If we scroll down, okay. Go farther.
Would you like to email you?
Please.
Okay.
Mr. Hernandez?
Yes, Judge. I guess just to address a couple of the points that Mr. Zembrink made, he did now my first argument, I think it's the most obvious one, is that the summary judgment rule 503.2 doesn't apply to eviction cases. And he did begin to read 500.3D, but he didn't complete it. And basically what that says in pertinent part, it says eviction cases are governed by rules 500 through 507 and 510 of part 5 of the rules of civil procedure. And then the next sentence says, to the extent any conflict between rule 510 and the rest of part 5, rule 510 applies. And so we look at rule 510, Judge, it covers eviction cases. And it articulates two ways that an eviction case can be disposed of. It's either by default judgment or trial. And you can find that at rules 510.6, 510.7, and 510.8. It doesn't provide a way to dispose of an eviction case by summary judgment. Now, if you look at rule 510.7, Judge, it says, if there is a trial, it is either by judge or jury, okay? Now, 510.7B says very clearly, and this is, I'm not saying this, that's what the rule says. It says if either party requests a trial by jury and pays the jury fee, then a trial by jury must be held. And must, I don't think I need to explain to Mr. Zembrink or to you, Judge, is a mandatory term that the legislature used. But it doesn't have to say only, because must covers it. Must says if either party requests a jury and pays the jury fee, a jury must be held. So there is a conflict between rule 503.2 and rule 510.7B. Therefore, if you look at rule 500.3D, then rule 510 controls and applies. Not you. There is no legal a proper basis to dispose of this case by summary judgment according to the rules. And I don't think I have to tell you, Judge, you've been an eviction judge for several years. I mean, how many eviction cases have you disposed of through summary judgment? And I don't think I think it's a novel situation because of the COVID situation that we're going through. But I think that if we look at the mandatory language of Rule 5107B, then I mean, Mr. Sanchez has requested a jury. He's paid his jury fee. He's entitled to a jury. And so that's my response to Mr. Zimbrink's, you know, trying to address my argument to that. I think the rule's very clear. But even if you decide, Judge, that, well, it does apply, there are genuine issues affecting dispute that does not warrant summary judgment in this case. And for that, you know, I could give you the facts, but I think it's important, since we have the witnesses here, that I can elicit those facts from the witnesses themselves. But there's genuine issues of dispute here that prevent a summary judgment. One of them is that this is a retaliatory eviction. Now, I understand Mr. Zimbrink's position that there was some kind of issue about whether or not Mr. Sanchez had paid the rent for February, and that's why they non-sued it. But it's our position, Judge, that this is just an extension of that original FED that was filed. We believe in retaliation because of Mr. Sanchez claiming his rights under the payday law because he was employed by the landlord. And I think there's evidence of that, Judge, without introducing any testimony. I think that one of the indications that there was a retaliation is if there's a rent increase from the rent that's listed in the lease. And, you know, first of all, the circumstances surrounding this landlord-tenant relationship, I think they're kind of interesting too, because this is a tenant that actually was being credited a portion of the amount of what the lease said he had to pay per month because he provided services for the landlord, and that he provided massage therapy for free to the tenants. And he was also a leasing agent for the landlord. And so there's kind of employment law mixed into this landlord-tenant relationship as well. But if you have a copy of the lease, Judge, and you heard Ms. Fragoso testify that the rental amount per month was $13.65 and he was paying only $200 because they credit him the rest of it due to his employment. She testified that they discharged him sometime in February, I believe February 19 or something like that. But there was an exhibit that was attached that I included, and it's the notice to vacate. This is the original notice to vacate, Judge. This was on February 19. And if Ms. Fragoso is present, she can contest this notice because apparently she's the one that gave it. But if you could share it on the screen, Judge, I would like for you to look at.
Your Honor, I would object to that. The original notice is not relevant in this case. The eviction cases are not subject to res judicata. We dismissed the original case, which demanded rent for February. So any evidence or information pertaining to February is irrelevant in this case, as we're not seeking compensation for anything from February.
So let me just understand that the first notice to vacate was given in regard to the first case, and the subsequent one was in the second case?
Yes, Your Honor.
Right. But we believe it's relevant, Judge, because it shows the rent increase that Ms. Fragoso demanded from Mr. Sanchez. And like we said, this is just an extension of the first FED.
If I may respond.
It is relevant, Judge.
Your Honor. Yeah, Mr. Hernandez is correct. The first notice to vacate likely had the incorrect demand. Again, that's why we dismissed that case. We felt that we could possibly have a faulty notice to vacate. Therefore, it's not relevant to this case. A subsequent proper notice to vacate was given. And that's the one at issue in this case, not the original.
Okay, I'm going to sustain objection in regard to the notice to vacate. I mean, if there's something incorrect on the prior notice, we're not going to bring it up to show some type of fault if they're acknowledging that it was a mistake and they dismissed it. Now, if you want to offer evidence that there was a rent increase, I'll allow you to do that. But
Well, Judge, that is a rent increase. They
if there's an
increased
error,
the.
if the
that is-
request was made in error, then
Yeah, Judge, you're not the jury. With all due respect, it's not your position to make that credibility determination. That's why we requested a jury, so that the jury can make a credibility determination, whether or not it was an honest mistake or whether it was a retaliation, and it was a rent increase. But I would like to put on Mr. Sanchez to question him a little bit more about some facts that establish that there are genuine issues of fact and dispute regarding retaliatory eviction, Judge.
Your Honor, I would object to any testimony, as this is a summary judgment hearing. They presented an affidavit with their response. Summary judgment hearings are generally not evidentiary hearings. That evidence should have been presented and filed with the court. I think we should be able to determine the summary judgment based on what's already been filed and submitted through affidavit.
Mr. Hernandez, your response to that argument?
Judge, and I think that I would be okay with that. And my argument would be, first of all, that this rule doesn't apply. Summary judgment doesn't apply to eviction cases, especially in this case.
I'm going to overrule you on that.
And then, second of all, Judge, there's a disputed issues of fact per the affidavit and the facts that were verified. These are the facts. Mr. Sanchez.
What affidavit are you referring to?
In our response to their motion for summary judgment, it's verified.
I'm looking at your response. Okay. Okay, what in the response are you referring to?
If you look at the third section, Judge, there exists genuine issues of fact and dispute. The facts are that he was employed for the landlord. He requested and demanded payments for commissions earned. They refused to pay him and instead fired him and filed a notice and filed an eviction suit. The notice to vacate indicates that they increased the rent. The original FED, they increased it even more. And these are factors that can weigh into whether or not there was a retaliatory eviction. Second, Judge, I think they've claimed that he's in violation of the lease.
In your response to the affidavit, I don't see, I'm reading your section 3.
Yes, that response is verified, Judge.
I understand it. I'm reading it, but I don't see anything where there's an increase in rent.
You have the notice to vacate before you, Judge.
I'm asking in your affidavit, do you point that out?
No, but that's why we have the witness here. That's why we have Ms. Fragoso here. That's why we have Mr. Sanchez here. I don't think there's any dispute that that was a notice to vacate. I think what they're claiming is that that was a clerical error or a mistake. I think that could be, that's a credibility determination, Judge, that should be made by a jury.
Your Honor, our motion for summary judgment is based on the lease amount. The lease is presented with our motion for summary judgment at $1,365. We're not asking for anything additional. We're not asking for late fees, utilities. There's no dispute that the lease has $1,365, and there's no dispute that he did not pay the March rent forward. I mean,
you're not entitled to late fees, Mr. Zimbring. You're not entitled to late fees, and you're not entitled to utilities. I mean,
Mr. Hernandez.
So of course you're not asking for that.
Yes. So based on our summary judgment as presented, we feel that there's no genuine issue of material facts because all of the other stuff Mr. Hernandez is trying to bring up is not part of our motion. We're not asking for that.
Hernandez?
Well, Judge, they can't ask for late fees. They can't ask for utilities on an eviction case.
They're not.
Exactly. And the only issue that we have in dispute, I think it's relevant, whether this is a retaliatory eviction, it's an extension of the first FED. The facts indicate that they did not file an eviction until after he requested his commissions that he earned. The Texas Workforce Commission has already ruled that he's entitled to that money. I think we have a real clear claim of defense of a wrongful eviction, Judge, and that's a dispute that needs to be resolved by a jury.
Okay. Anything further?
Can I say something, Judge?
Yeah, Mr. Hernandez, do you want the person
Absolutely, he can
to say something?
he can speak for himself.
Judge, pretty much, I worked for the apartment for like 1 month as a leasing agent, and I believe that I did my best leasing apartments. I didn't knew anything. Mr. Fragoso was out of town, so I wasn't even trained. But I did my best to learn and to do my best as customer service and sales agent. I actually leased 15 apartments in which I believe that I put a goal, I reached it, and they never pay my commissions that I pretty much work for them. And this is pretty much why we're here. I'm pretty much making justice that I work for something, and when I asked for it, they decided to fire me.
Okay.
That's all.
Anything further?
No, sir.
Anything further from Mr. Zimprich or Mr. Hernandez?
Nothing further, Judge.
Just to reiterate, the section 92.332 non-retaliation specifically states that if the defendant is delinquent in the rent at the time the notice to vacate is given, it's specifically deemed non-retaliation. He was at that point March, April, May, June, July, August. He was 6 months behind in his rent when we provided the notice to vacate and subsequently filed.
Mr. Hernandez?
Yes, Judge. As I stated earlier, the fact that they non-suited, it had nothing to do with what he claims. It was basically a legal maneuver to try to make that argument that he just made. And the facts are that this is just an extension of the original FED. And no matter how much Mr. Zimprich strains to draw the distinctions, it's very clear that they only initiated eviction proceedings because he asked for his commissions. And that's retaliation, Judge.
Okay. Okay, Mr. Zimprich, you had a proposed order? Did you submit it?
Yes.
When did you submit it? I'm just trying to locate it.
I sent it to Ben yesterday.
Okay, let me see if it's on this next page. One second. Mr. Zimprich, we did receive the order on the CDC declaration. We can't locate is there another order?
Yes, I will send it right over. Okay, it should be on its way over.
Mr. Zimprich, you have in here the court finds the amount of $2,730 is the appropriate amount for the appeal bond. How did you come to that?
I just put
Why are you requesting that?
2 months of rent, but whatever your honor feels is appropriate.
If this is an eviction for non-payment of rent, it would be the monthly rent.
Okay, 1 month's rent.
Yes.
So it would be 1 month's rent, and then he would continue to pay the rent as it accrues?
Yes, Okay,
Thank you with that. Sorry about that.
no problem.
I apologize.
We found your order too.
Okay.
Apologies.
The attorney's fee statement that I presented, I left that blank because I wasn't sure what your honor would feel is appropriate. Again, I only included the attorney's fees associated with the subsequent case, and that was $3,833.30. And I did send over the billing timesheet yesterday as well.
The same email? Oh, yes, okay. Mr. Hernandez, do you have anything, any argument in regard to the attorney's fees?
No, I didn't see an affidavit of attorney's fees. I just saw like an itemization. So, I mean, that would be my only objection. I mean, but
Mr. Zimprich, is this motion for summary disposition? Can you supply an affidavit on the attorney's fees?
I can, I just put in the motion that I would testify as to attorney's fees.
Okay, if you could follow up with an affidavit.
Okay.
I'm not coming. I think you're well worth the $250 attorney's fees. Just in the light of the situation we're in and rents and so forth, I'm going to award $2,500 in attorney's fees.
Okay, thank you, Judge.
But I still need the affidavit.
Yes, I will file that in the case.
The only other thing, I don't know, Ben or Juanita, I don't know if you're listening, is can you confirm the judgment rate? I think it's 5.25. One of y'all can answer.
Yes, Judge, that is correct.
Okay, so I'm gonna change that to 5.25.
Okay.
What happened? Oh, we lost. Yeah, we'll get a copy of this order to you all.
Thank you, Judge.
Anything further?
No, sir.
Nothing further, Judge.
Okay, thank you all.
Thank you.